Ladies and gentlemen of the jury, good morning. My name is Attorney Nabi Ayad. I represent the defendant in this case. I want to first of all thank each and every one of you for participating in this such very important process of our criminal justice system. Our system in the United States is the best system in the world. It's not perfect, but it's the best system that we have. And it's because of processes such as this, as your individual, where this defendant is being judged by individuals of his peers. Not by law enforcement, not by all due respect by the judge, but by his peers. And this is a case of an individual that was killed. There's a loss of life in this, and we don't take that, we want to take away from that by any ways, means, or form. It's unfortunate, and our blessings go to the family of the deceased in this particular case. But unfortunately, for the prosecution, they simply just cannot prove their case. And you will see this throughout the trial. The prosecution has numerous hurdles. And I agree with Brother Counsel that, yes, thank God for us and thank God for the jury that there's video of the entire incident. The number of cameras with different shots and different views. You can see exactly what happened. The only thing you're not able to see is, or hear actually, is what was said during those conversations. But you can tell by the movement, by the gestures, by the hand gestures, and things of that nature, in your mindset what a normal person would think what was going on in that particular bar that evening. Talked about hurdles. The prosecution has this issue called causation. And you'll see in the murder charge, it says proximate result. There's a purpose for that. The purpose is that this defendant killed the individual. There's a proximate result, is that he's the individual that did it. You're going to come see that the prosecution has numerous hurdles. One is that the medical in and of itself doesn't clearly show that this defendant actually committed the act. You're going to see that the deceased, the victim in this case, was under the influence, legally intoxicated, had marijuana in the system, had fentanyl. You're going to see that this fentanyl, you can't even purchase it from the pharmacies. You can only get it at a hospital. It must have been either he was in a hospital or that he got it off the street. We know how dangerous street medications are. You're going to see that he had a prior brain injury. He was taking seizure medicine. And add to that his age of 59 years old. You're going to see that not only did he have a hemorrhage, but he also had a stroke. A stroke. A heart attack. Our expert is going to come in and testify to all of this. To all of this. We're going to testify to the procedures done at the hospital. But the hospital in and of itself was grossly illegal committed doing procedures on Mr. Valdez. That's one causation or proximate result that they're not going to be able to prove. Another one we have is there's other individuals that were in that fight. He didn't act in a vacuum. Mr. Wimpey didn't act in a vacuum. There was other individuals there. And one you would see is Mr. Mossad. Cal Mossad walked in with Mr. Wimpey. You're going to see that Mr. Mossad also grabbed the deceased and threw him in a violent manner to the ground, who at one time hitting his ground to the floor. Hitting his head to the ground. You're going to see that there was other acts as well against this deceased. We're going to be able to show that they really can't say which punch, which kick, which fall to the floor actually caused the deceased's death. We know that Mr. Wimpey hit him. We're not denying that. Of course he hit him. He was in a fight. But they're not going to be able to show who did it in that sense. Let's fast forward now and say, let's assume Mr. Wimpey did do it, and the prosecution was able to establish that. Even though we tell you that, or they're not going to be able to show that. But let's say they did that. for this particular charge, murder B, you see the particular charges. It requires death. We know that that's been met, death, the person died. Proximate result, again, we don't feel that they have, but let's assume they have, for argument's sake. There's an act of violence, the underlying felonious assault. You're going to see again by the expert testimony, by the other person that's involved, they can't even establish that. But let's give them that too, felonious assault. But here's their overwhelming problem. This hurdle they cannot. Even assume they pass hurdle number 1, hurdle number 2, they simply cannot overcome this. And that is under the Ohio statute of murder B, 2903.02 subsection B, it requires that the defendant was not provoked. Was not provoked. And the statute is very clear that, and this is from the indictment in of itself, it says the degree, and that was not violation of 2903 or 2903.04 revised code. And ladies and gentlemen of the jury, 2903 deals with provocation. If this defendant was provoked, then that cannot be murder. And there's no doubt that you're going to be able to see that this situation, this defendant was provoked. In addition, 2903, and it also says that if it's in violation of 2903.4, which is also another section of that statute, which deals with unintentional. Unintentional. Not, provocation is not murder, it's voluntary manslaughter. When it's not intentional, it's involuntary manslaughter. The legislatures in this state put those certain rules for a reason. It's not just murder, you're going around murdering people. There's one for a lesser section that you're provoked, which is a voluntary manslaughter. There's another section that's when you didn't intend to kill the individual. Involuntary manslaughter. For situations such as exactly this, where the individual didn't intend to kill him. Who in their right mind will think that a one punch will kill a man? We all watch boxing. We all watch UFC fights. People go down all the time. And at times they even get knocked out. But hey, they shake up a little and they get back up. No one intends death on the individual by just a punch. You'll see nowhere in that video that the state is going to be able to show that this defendant had any kind of weapon. Did he have a gun? Did he have a knife? Did he have a pool stick? Did he have a bat? None of that. He didn't have anything. He just had himself. The evidence shows he's not a UFC fighter. He's not a boxer. He's just Mr. Carl Wimpey. That on that evening was just going, minding his own business. Him and his friend. You're going to see that he didn't even know Mr. Worforth. He was just going, having a drink with a friend. That's it. They picked him up after dinner, going to have a drink, minding his own business. And there's where you're going to show, look at the video. This is, thank God for this video. We're going to see this man was just simply just standing there. Who approaches whose space? Who comes into whose space? You're going to see at one time, Mr. Wimpey just having his drink. He has not only Mr. Richter, which I call this guy, he is, as the counsel said, he's the star of all. He's why we're here today. He's what I call the Chihuahua. He keeps coming. He keeps coming. He keeps coming. Then there's another individual that Mr. Richter doesn't know. Mr. Wimpey doesn't know Mr. Richter. He doesn't know Mr. Sharp, the other individual. He doesn't know the deceased Mr. Vanquist, Mr. Richter's uncle. You have three guys just standing in their space. Mr. Wimpey does not leave his space. They come to him. They approach him. You're in a bar. You don't know these individuals. They're coming at you. Think to yourself what an ordinary person will do. We can all talk about after the sentence, but what would an ordinary individual do? When you're looking at that, and one of them is just hyped. You see his eyes are fuming. You'll see a picture of him, tattoos up to his neck. He's just coming at him. What is he to do? And then this individual, not only he's in a sling, but he goes and grabs a pool table, a weapon, and comes at him, shaking it like he's about to assault him. And the prosecution is going to want you to believe this. Hey, walk away, turn your back on an individual who's about to assault you with two other individuals you didn't even know. Anyways, we'll move forward. They're not going to be able to show that because one of the exceptions that you cannot convict on murder is voluntary manslaughter, which is, again, he was provoked, which clearly he was revoked, and 2, involuntary manslaughter, which he didn't mean to kill. He didn't have a weapon, he didn't mean to kill.
Sidebar, please. We have to wait till the court orders something back up.
Ladies and gentlemen of the jury.
Just
So,
one.
I'll have to wait till the court orders something back up.
I'm all set, sir.
Thank you.
Thank you.
As it stands right now, these are the charges brought against the defendant. Whether there is a lesser included offense that the judge may instruct you or not instruct you, that's for, right now, it's not to be considered at this particular stage. But they may be down the road throughout this trial. I'm asking this jury to please look at the video, look at the personal space, look at the individual, Mr. Carl Wimpey, where he was standing comparatively to everyone else. Look whether he violated anyone's personal space. Look at whether he was holding a weapon or not. Look whether this defendant continuously used a weapon or continuously punched the deceased, or continuously chased him and kept going at him and hit him and hit him and hit him. You're not going to see that. You're going to see a one left jab punch. You're going to see testimony that my client is not left-handed, he's right-handed. You're going to see that Mr. Richter grabs a weapon on 4 different occasions. Pull stick the first time, pull stick the second time. You're going to see 2 beer bottles and then another beer bottle. That's a weapon on 4 different occasions. Even if you adopt the prosecution's belief that he should have just walked away, guess what? His theory, this defendant's theory, we're going to be able to establish was absolutely correct. He did walk away at one time. Him, Mr. Cal, Mr. Wolford, left the bar. He didn't even finish his drink. He just left the bar. We want no more of this. Within 5 to 10 minutes, all of this happened. Just trying to have a good time, have a drink, and he left the bar. Guess what? That little chihuahua I'm talking about didn't end it there. He came out, grabbed 2 weapons, 2 beer bottles, swung them hit the truck, hit another, swung him again, hit another truck, hit him again. You're going to see that Mr. Masad parked his truck back up again. You're going to see that Mr. Wimpey was not even driving the vehicle. Leave where? He wasn't even driving. He went to the defense of his friend because his friend ran back into the bar. You're going to see that while in the bar, and please do not buy this angle that, with all due respect to the dead and deceased in this situation, that he was just simply trying to break up a fight. He was a participant. He was clearly a participant. You're going to see the face gestures of Mr. Vasquez, the deceased, how he looked at this defendant. You're going to see how he attacked the defendant, grabbed him in a bear hug. You're going to see, and even at one time, when they came back into the bar, Mr. Vasquez punching Mr. Cal. That's not a person who's trying to break up a fight. That was a participant in the fight. And you're going to see actually an individual that did try to break up the fight. His name is Douglas Sharp. Look at him in the video. Let's see it in the individual that's truly trying to break up a fight. He wouldn't sit there and go after Mr. Wimpey, grab him in a bear hug. He would, you think common sense would dictate that he would grab his own nephew and hold him back and say, "What are you doing, nephew? You're in a sling. This guy's almost twice your size. What are you doing?" But you're going to see Douglas Sharp, the other individual, does not participate. He's actually trying to break. He's the one that's trying to break it. Mr. Wimpey doesn't punch Douglas Sharp. Neither does Cal Mossad, the other participant in the fight, doesn't punch Douglas Sharp. Why? because in their mindset and their view of everything that's going on, their adrenaline's going, they didn't feel that person was a threat to them. It's not only this defendant. Thank God for us and for you, the jury, we have other individual that was involved, and that other individual did exactly what this defendant did. Was punched to secure himself. Whoever's in his vicinity, he's like this. Boom, boom, whatever's in the vicinity just to protect himself. And so did the other defendant. They didn't hit Mr. Sharp because Mr. Sharp was not involved. That should say a lot about what this defendant was thinking at that moment, at that time. And then look, when he tried to leave through the beer bottle. Then, after that, he tried to leave again. You're going to see that this Chihuahua came back out again with a beer bottle, weapon in hand, was about to hit him again. But this time, they backed up and they kept backing up, just to do what? Watch the individual, watch this Arthur Richter, so he doesn't hit him again. But see, that backing up is important, ladies and gentlemen, because guess what? That vehicle didn't turn the back against this person that was assaulting. That's like exactly why he didn't want to turn his back on Mr. Richter, because he knew in his mindset what would happen in that particular matter. He would get hit. So he couldn't just walk away. You're going to see that we're going to be able to show that this defendant acted absolutely in self-defense of himself and self-defense of his individual partner that was there, Mr. Cal Prasad. They were both not the aggressors in this particular case. Please look at that. I think it's going to be undisputable they were not the aggressors. Going about minding their own business. He doesn't even know Mr. Wherefore. He was picked up and he was just having a drink. And lastly, see the statement that Mr. Wimpey, this defendant, goes in and voluntarily makes to the police. Once he knew that he was charged, voluntarily walked in, makes a statement to the police with his attorney sitting there. And he says, and look at his body, I was just defending myself. You know, that's what I was doing, you know. He was not the aggressor, ladies and gentlemen of the jury. After you see all the evidence, all the testimony, you would agree with me first that they have not met the charge of murder. And even if this prosecution comes in with an additional lesser included offense, they have not, I strongly believe, would not have met that. But even if they did, self-defense is a defense to all of that. Thank you.